there was an application which was made by Senior Counsel and he ably submitted. He shook this court in submissions. And that's the reason why we applied for standover to have our response. It is therefore not fair for them to make bad and good their own case before we respond. Let them allow us to respond. There's nothing we need from the applicants to help us. It is the application, so we pray that the application for leave to make clarification is denied so that we respond because they have time to rejoin.
Well, before we step out, the applicant had actually put his application before court. And it was the respondent who asked for his standover. So let's listen to the respondent.
Most of the Josh, in response to the application, first of all, by the time Senior Counsel Kwago made the application to stay the proceedings and also asked for the record, this court had made a ruling to the effect that the application number 01 of 2025 be had in chambers as the magistrate or the trial magistrate was standing up, counsel simply said, as an application like. That in itself was irregular. Because at that time, the hands for applicants and the respondents were tied because the ruling had been made. The only way Senior Counsel was, by all means, supposed to make that application was to seek leave of this court, which he never sought. That in itself hits the applicant's hands down. That said, my senior colleague talked about so many things, including jeopardizing the case for applicants. However, we are on record as prosecution for ensuring an expeditious trial, an expeditious investigation in this matter. We wish this court to take a note of the fact that the prosecution is being twisted by the accused persons, in which case the intention is to delay both the investigations and the trial. So, on the other hand, as the prosecution is trying to execute its mandate, it is being blocked, it's being frustrated, it's being twisted by the defense, which shouldn't have been the case. We expected the defense to be the main facilitators of the first investigations under trial of this matter, but we are surprised. Defense made an application and cited several provisions of the law. He cited section 17A of the Judicature Act, 17.1 of the Judicature Act, which talks about the supervisory powers of the High Court over Magistrates' Courts. Most obliged. And also cited there, he cited the section 33 of the Judicature Act. Let me read it back to you, because what the press will hear. We are bringing this application under section 33, which talks about treatment of life imprisonment or imprisonment for life in any enactment. That is the law under which the application was brought. This is bad law. This is bad law. Your worship, the details are there, and wish court to capture it as part of the application. 2. Council made a prayer to stay proceedings, that this court stays its own proceedings. However, that assertion, or that prayer, is not grounded. He never provided or cited any authority, either statutory or case law, that gives this court, empowers this court to stay its own proceedings. In a scenario where it has been just informed by the applicants that they intend or they anticipate to make an application for revision in the High Court. This court is not supernatural. This is not a court of prophecy that will determine that the applicants are going to make an application for revision in a 2 or 3 or 1 month time. The only court that has the powers to stay the proceedings before this court is the court that is doing the revision. And therefore, the applicants to that effect in this application should first of all have sought that order from the court that will hear the application for revision. Because that court has control over proceedings before it. And therefore, it can tell the timelines that the said application will be heard and disposed of. Which, that's your worship, this court doesn't have. And therefore, it is redundant. It is a redundant prayer to ask for stay of proceedings in a lower court. This court cannot again stay proceedings before it without evidence that an application for revision has been made. We don't operate in anticipation. Courts of law operate on facts and evidence. So the issue is, what if the applicants file the application for revision after 1 year? So our view, my colleague will submit on the record of proceedings, but I am of the view that this court does not have powers to stay its own proceedings without grounded statutory law and case law. we were supposed to have this matter heard in chambers. And I believe that this court will not have erred in any way to have application number 01 of 2025 heard today and disposed of, so that we fast track the investigations in this matter and ensure a speedy trial for the applicants in the main case, that is 008 of 2025. The public, Your Worship, you might not really something about that, how it's going to be done. The public and the press have less contribution in application number 01 of 2025 because they are not going to make an argument before this court. None of them saw an affidavit on record. And therefore, their input is at the periphery. Eh? Their role is peripheral, if I'm to say it. My colleague will add on that.
Just proven that the sections that have been cited by our land friends, that is section 17, it gives supervisory powers to the High Court over the Magistrates Court, and sections 48 and 50 under the Criminal Procedure Code, that purpose they relate to the nature of proceeding in division, gives the High Court these powers to call for and examine the record of any criminal proceeding before a magistrate's court for purposes of satisfying itself as to the correctness, the legality, the propriety of any finding, sentence, or order recorded or passed, such as the one this honorable court gave, and as to the regularity of any proceedings of the magistrate's court. These powers are solely given to the High Court, and therefore, for the defense purports to ask this honorable court to inherit itself of these powers. It's not correct. The legal of course that my colleague earlier commented on or submitted that they should have sought leave from this honorable court. It is their right to apply for a record of proceeding and ruling of this court. However, for it to be the basis upon which they want to file an anticipatory revision should not be entertained by this honorable court. And it is our humble prayer that it is responsive and they should file this application before the right court as they have allotted.
What I wanted to do was to put things in their perspective. Yes, I'm responsible. So that my colleagues respond appropriately. My senior colleague, Mr. Wabo, frames the application section 14. That was the section. We referred to section 17 in support of section. What he said was that he had instructions to refer the matter to the issue. It is in section 48 and not section 17. Your Worship, under the Judicature Criminal Procedure Application Rules, SI 13-8, that process can be commenced by letter. It is therefore erroneous and perhaps deliberately so, because I don't want to assume that it doesn't, that you don't need to file an application. So when council says you can't file an application in 1 year, I don't want to assume that you are letting go of the process. It would ensure take council 1 year to write it. Then again, it has been written, and perhaps the systems would have shown you that the application is there. Your Worship, the instructions of the applicants are to seek a revision, not an appeal. The sections cited do not require leave of this court, and we need to be emphatic. We are not here to ask for permission of this court. It is a right to refer the matter to this issue. It is nowhere indicated that we must seek permission of this court. So again, because I know that Mr. Birivumbuka knows this, I don't want to assume that circumstances are causing him to do what is wrong, especially when it's still the early part of the month, when all of us have just been paid.
So let council please restrain the matters that are now before court.
I agree with my style to be emphatic. When the government has injected resources, we ought to do the right thing, because that's what we are called to do. So, Your Worship, what Land Council Area Supervisor said was to inform court that we are going up to the higher court. We do not need permission of this court because it's not provided for anywhere in any law. It also ought to be remembered, Your Worship, because Council has said we should have filed an application. We don't have the benefit of lead cards like him. This matter was put over for 30 minutes. We could not go away to file an application and come back to this court in 30 minutes. We were just good mannered to say we are going to a higher court. Please hold on until the higher court makes a pronouncement about the matter. My colleagues referred to the lack of an authority. It is what I was going to refer to when he quickly spoke to me. Unfortunately, now that he spoke to me, we wouldn't have an opportunity to respond to it because he would have only been a little patient. Your Worship, it is common sense that if the High Court is going to review proceedings in the lower court, the file of the lower court must be before the High Court. So when the application is filed, and it will indeed be filed today, the High Court will make a pronouncement to call the file. For this court to proceed with the cross-examination in camera and end today, when we are seeking a review of that decision, would surely not make sense. That's what I'm saying, it's common sense. Because then there will be nothing to review because the cross-examination has happened. We don't want to take the people through the bother of returning if the court says that we should do it in the open. It's common sense. Your Worship, also, The spirit of our argument is founded in the well-known decision of Charles Onyango Obo and Andrew Mujuni Mwenda versus the Attorney General. Your Worship is the one I wanted to point my colleague to when he said I shouldn't. In that court, my lord, it is Constitutional Appeal number 2 of 2002, Supreme Court of Uganda. His earlier submission was that the High Court doesn't bind this court. I thought he would have that the Supreme Court binds this court. Your Worship, in that decision, the Honorable Justice Mulenga, RIP, who delivered the lead judgment, said that when a court seized with a matter becomes aware that the proceedings are under challenge or are going to be a subject of the challenge, it must wait for the decision of the higher court. The rationale is to avoid a diversity of justice and to avoid applying the law or taking action whose validity is questioned. In other words, it should wait for the higher court to make a pronouncement as to whether it should continue or not continue. That is what we are saying. We are going to the high court, which, as far as we know, is higher than this court, and it is only good, even for the record and the judicial officer, to wait for the higher court. Your Worship, we want to avoid a scenario, as happened in the decision of the Honorable Moses Kasivante and Paraminda C, where the lower court went ahead to conduct a recount, despite the matters being challenged by the High Court before the Honorable Justice V.A. Prosecution, RIP, whereby the judicial officer at the lower court became a subject of disciplinary proceedings. We want to avoid that scenario and say that let the court wait and we go to the High Court. We are reminded, my Worship, and we go to section 50, subsection 2 of the Criminal Procedure Act. Your Worship, the position of that section, section 50, subsection 2, is that a review cannot take place without the DPP being heard. So those proceedings of under review, these ones are going to be under review, are going to invoke the DPP. It is in that forum that the DPP is heard, has audience. The DPP cannot object an accused person seeking to enforce their rights. It is wrong. I want to assume that if my two colleagues were in the dock, they would be ashamed and angry at someone standing in their way of enforcing their rights. So it is wrong for Mr. Birivumbuka to argue that when an accused is seeking to enforce their right, they are frustrating a process. The accused persons are not the authors of the law. They are relying on a provision of the law which they are entitled to. It doesn't matter that relying on that provision of the law causes proceedings to stay. It is their right to do so, and they are fully entitled to invoke that right. In any case, Your Worship, unlike the state and these two representatives here, it is the accused person to have no liberty. So if the delay is going to cause them to go back to prison, I shudder to think of the concern of Mr. Birivumbuka. They are taking the risk of sacrificing their liberty to see that the right thing is done, and they are empowered fully and to invoke their right. Your Worship, I wish to conclude. By saying that the arguments by my colleagues cannot stand in the way of the rights of the accused person. The rights are provided for by law. They don't have their liberty. If they choose to invoke that right, they take the inconvenience that comes with invoking that right. And lastly, the Worship. Because our colleagues blamed us for doing this application before we filed a formal application, we just state that this court stood over the matter. The accused persons were returned to custody, which is under very tough guard, as can be seen. We didn't ask, so we didn't speak to them. We had to obey orders and stay here and wait for court. And again, as my land friend Mr. said, we are not asking this court to revise this decision because it doesn't have that power. We are asking the court to do what we think is reasonable, to hold on to continuing with the decision it made until the higher court revisits that decision. It is not an appeal. It's not brought under section 17. It is brought under section 48, which, if once the application is filed, the High Court will call that file. So it is not proper, Your Worship, to take your time to sit in an application to hear a cross-examination when there is a possibility that those proceedings will be recalled if the court agrees that the hearing should not proceed. That's our submission.
In respect to all the issues, one, the jurisdiction of this honorable court in regards to the state of its own proceedings. Our friends across the aisle argued that we do not cite any provision in giving this court to state its own proceedings. In other words, we are suggesting there is a vacuum. It's going to contain the famous of the law. We don't leave any vacuum in that area. In the contrary, Your Worship, this court has unfettered powers to manage its own proceedings and processes in situations of this nature. We refer you, Your Worship, the provisions of Section 9 of the Magistrates Courts Act. If I may, Your Worship, just for emphasis sake, to read it out verbally, how general jurisdiction is exercised. The jurisdiction of a magistrate's court shall, subject to this act and any other written law, limiting or otherwise. Let me get this one, read it from this volume. How general jurisdiction is exercised. The jurisdiction of the magistrate's court shall, subject to this act and any other written law, limiting or otherwise relating to the jurisdiction of that court or of the presiding magistrate, be exercised in conformity with the law with which the High Court is required to conform in exercising its jurisdiction by the Judicature Act. Your Worship, my interpretation of this particular provision, this court is broad with wide jurisdiction, just like the High Court has got or enjoys that wide discretionary power in managing its processes. And I think this answers their question as to the applicability of Section 33. Since now they are satisfied that Section 33, the former Section 33, sorry, of the Judicature Act. Therefore, yeah, we are getting acclimatized to the revalidation, and that's not a good deal. So, Your Worship, the widely discretionary powers enjoyed by the High Court under the Judicature Act are the same discretionary powers vested in this honorable court, including powers to stay its own proceedings. And this reinforces the issue of logic that my grandfriend successfully submitted on that particular internet. And that also resonates with the spirit of Section 43 of the Judicature Act. That is the former provision I wish to correct that, Your Worship. Having said that, Your Worship, just to emphasize because now they argue that what if it takes a year before we file? That again brings me to the powers under Section 9 of this majesty to manage its own proceedings. Your Worship, you have powers to set timelines. To say, yes, we recognize you have a right to seek for the intervention of the Superior Court by way of revision, but it's not an open check. And of course, we can draw parallels with appeals. That's why even appeals have got timelines. That you have a right to appeal within 14 days. You have a right to appeal within 30 days. So it's very simple here for the court to invoke its powers under Section 9 and 43 of the Section 9 of the Magistrate Courts Act and 43 of the Judicature Act to say, yes, we recognize you have the right and you have clearly indicated that you are pursuing that right. We are adjourning these proceedings for a period of 2 weeks, those are 14 days, within which that right should be exercised. And in that way, justice will be done. But now look what they have decided. If you were to deny that right now you retreat to the chambers, you go ahead with cross-examination, but still tell the accused persons or the applicants in this matter that you have a right to seek for revision of my order when actually you have proceeded with the cross-examination. Would that really make sense? This is what we are trying to avert. That actually, if you proceeded that way, Your Worship, you'll be rendering the right to seek for revision illusory. It will be negatory. It will be useless. And that will be a travesty. And that's what we are trying to challenge. And actually, it will make matters worse. And it will reinforce further our application for revision if we proceeded, Your Worship. To reinforce.
So you said you want to
the last one, Your Worship, the accusations made against us. Very, very unfair. I don't know the words Mr. Birivumbuka used. I'm Christine, blackmail, doing this. He used lots of words. They were very, very unfair. Very, very unfair. I think he owes us an apology. You should return to those statements with an apology. We are here to facilitate this court to dispense justice, not to block the way to justice. If anything, actually, it's our client who are craving justice, who are interested in having justice done to them. This is not justice to Mr. Birivumbuka. It's not justice to any of this, but it is justice to the applicants. So it will be very, very unfair, grossly unfair to tell the accused persons who are seeking to enforce their rights to get justice that they are imprisoned people, that they are blackmailing people. Very, very unfair. So I pray that he reflects on this, and before ruling is made, he accepts to have that expunged from the record. I am appealing to his good self and conscience, to his conscience. I do so very well.
And therefore anticipatory at this point in time. The normal procedure, as defense has put it, is to file at High Court, which calls for the report. They have, however, indicated that time is of the essence, and since the court made the ruling this very day to proceed with the cross-examination, should court continue with the hearing of the said application, the rights of the accused applied for review will be granted upon. Yes, this court can stay its own proceedings, but only upon proof of an application at High Court, for which the High Court itself will call for the file, not in case of the anticipatory matters to be filed. However, to enable the accused person to exercise the right, this court shall adjourn this matter for mention to the 30th of April
2025.